All members will please come to the House floor. Mr. Clerk, will you ring the bell, please? House will come to order. We're getting ready to move on to the rules calendar, or should I say begin the rules calendar. I don't know who made this plan. House will come to order. Mr. Clerk, will you read the caption to Senate Bill 395?
Senate Bill 395 by Senator Kirkpatrick of the 32nd and others to be entitled an act to amend Chapter 2A, Title 31 of the Official Code of Georgia annotated relating the Department of Public Health so as to require a physician to submit certain information to the Georgia Composite Medical Board. This bill then referred to the Committee on Public and Community Health. That committee recommends that this bill do pass by Rules Committee substitute.
Okay, members, good afternoon. We're going to recognize Chairman Newton to present Senate Bill 395. The gentleman is recognized.
Thank you, Mr. Speaker. I bring to you Senate Bill 395. It is actually, like a lot of things this time of year, does have a couple of medical care areas in it. I'll begin with the bill as it started. Long ago, when we first started the medical cannabis program, we set it up under the Georgia Composite Medical Board exclusively. Later, it was determined that those cards and the registry were better held under the Department of Public Health. So a good bit of the language was moved to the Department of Public Health. in doing so, we also added, like all kinds of health care, where there's a certain amount of privacy that's expected, so we limited who the Department of Public Health could share their information with. On line 35 of this one, it just adds a simple thing for the Department of Public Health to be able to release information to the board. That's the Georgia Composite Medical Board, who oversee our licenses and those or whether or not the doctors are following Georgia's laws on certifying and following up on medical cannabis treatment. It says it releases it to the board for investigation, compliance, or disciplinary purposes. That was the goal. That is the goal of Senate Bill 395. It does a couple of patient issues. It changes on one line what was requiring the doctors to do a semi-annual report to annual. That's more in how we do a lot of medical conditions, is an annual feedback from a physician. So this just put semi-annual to annual, and also said that if the doctor or a doctor's office doesn't turn that report in or fails to, there's no reason to punish the patient by making them start over with their registry card, even though they still continue to have the condition which they may have had. So that's what Senate Bill 395 has done. We have added a section 2 to this. House Bill 154 by Representative Richardson earlier established EMS as an essential service. Didn't change anything about whether an insurance company does or does not pay in-network. It doesn't require different things, but by declaring them an essential service, it made the EMS crews, especially in some of our rural areas, it made them eligible for government grants. And so that's all the second section of the bill does. I'm glad to answer any questions on either one of those medical topics.
The gentleman has no questions.
Thank you. I appreciate your favorable support on SB 395.
Gentleman's yielded the well. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to withdrawing the committee's substitute? Hearing none, the committee's substitute is withdrawn. Is there any objection to adopting the substitute offered by the Committee on Rules? Hearing none, the Rules Committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. Those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted? If so, Mr. Clerk will lock the machine. On the passage of Senate Bill 395, the yeas are 161, the nays are 0. This bill having received the requisite constitutional majority is therefore passed. Members, we have a further action that's on your desks now that we will take up, and I'm going to recognize Chairman Newton for a motion.
Mr. Speaker, I move this body agree to the Senate substitute for Senate Bill 220.
To the Senate amendment,
I'm sorry, to the Senate amendment to
House
Senate
substitute.
Bill 220.
Thank you. Mr. Clerk, will you read the caption?
Senate Bill 220 by Senator Brass, the sixth, and others being titled an act to amend various provisions of the Official Code of Georgia annotated so as to rename low THC oil as medical cannabis.
What's the number? The amendment is SB 220 SFA. You have that? That whole row, do y'all have that on that row? Some of them in front of you have it. Page ladies, we're missing an entire row that I believe, maybe two rows.
This one?
While you're waiting for a hard copy, we're going to put it on the screen. Members, insomnia and arthritis came out, and intractable pain or lupus was added. Those are the changes. Intractable pain, I'm told, was already there. We're getting close to having everyone have a copy.
He was saying that's why we was taking so long.
Representative Clark, does y'all's row get some now? How about to my left? Y'all have copies now? The amendment is on the board, and you should have the hard copy. If you don't, raise your hand. Chairman Newton is recognized to speak to the changes.
Guys, I apologize for the.
Wait, hold up. I got ahead of myself there. Recognized for a motion.
I move the House accept the Senate amendment to Senate Bill 220 as shown on the board and on your sheets.
Senate amendment to the House substitute to SB 220. Mr. Clerk, will you read the caption?
Senate Bill 220 by Senator Brass, the sixth to be entitled an act to amend various provisions of the Official Code of Georgia annotated so as to rename low THC oil as medical cannabis.
Chairman Newton, you're going to speak to the Senate amendment to the House substitute, SB 220. Is that correct? Gentleman's recognized.
Thank you, Mr. Speakers. Colleagues, I want to appreciate all of you for the support we did moving forward with both tightening up the role of the physician in our current medical cannabis laws, but also kind of considering the patient's needs foremost in our recent change and substitute, our House substitute for Senate Bill 220. The Senate did amend our bill in a couple of small ways. We had agreed to add lupus, and the Senate did agree to that because that had been brought by both the Department of Public Health and the Georgia Composite Medical Board. Our House committee had added severe insomnia and severe arthritis. Intractable pain was already in there, but we added severe arthritis and severe insomnia. The Senate recognized that several years ago this body said new conditions should be evaluated first by the Georgia Composite Medical Board, and so they elected to take out the addition that we added of severe insomnia and severe arthritis. Arthritis really could come under intractable pain if it's really to the level we were looking to treat. So that looks like that's still a condition that can be treated. Lupus, everyone agreed on. The second change, other than taking out those two conditions that our committee added, they did also make something subject to appropriations when we asked the Department of Public Health to transition over from a certified mail hard copy card to a secure electronic card. Department of Public Health asked us if we would put subject to appropriations on that because they want to make sure the funding is there to actually do this and do this in a professional and secure, not copyable way. And so those are the two changes the Senate added. The gist of the bill and its goal to help patients stands. I'm glad to answer any questions, Mr. Speaker.
Yes, you have two, I think. Representative Cummings, Representative Terry Cummings to your left. Ladies recognized.
Thank you. Does the gentleman yield?
Yes, ma'am.
I'm just trying to get a hold of why arthritis was taken out, especially, like serious arthritis. Why would that be removed? I understand what you said about intractable pain, but why take it out?
It's a good question, and we recognized when we added severe arthritis in our study committee, we did recognize that it could already be treated by your doctor through the intractable pain codicil that's already there. We wanted to add it specifically, but the Senate they were not wrong in pointing out that this body, along with the Senate several years ago, asked for all new conditions to first be vetted formally and in writing by the Department of Public Health and the Georgia Composite Medical Board. So it's my full intention for us to bring those up to both those bodies to add, to look into adding severe insomnia and severe arthritis back. I do believe the arthritis can be taken care of under the bill the way it stands now and the way it'll stand after this amendment, should it be accepted. But thank you.
That the gentleman yield for further question.
Sure.
You just said, so the doctors, severe rheumatoid arthritis is a recognizable medical condition.
Yes.
And I'm thinking I'm missing the point where you said it was removed because there has to be further documentation
I'm
about
sorry.
it.
Ask that one more time. I'm sorry.
You mentioned that the condition has to be documented, and of course, rheumatoid arthritis is not a new condition. It's not a new medical diagnosis. It's been around for decades. So I guess I'm
Oh, I'm
trying
sorry.
to figure out, based on what you just previously said, if it's, why would they have to go back to redo it?
No, I'm sorry. I don't mean that the patient has to go to their doctor to get the diagnosis. And you're right, it's a decades-long issue. This is whether or not it gets on our list of 17, 18, or possibly 20 conditions that would approve you independently for a medical cannabis card. As I'm saying, if someone does have severe arthritis that has intractable pain, they're eligible now to get what they need if their doctor feels like they need this. I don't mean they have to go get diagnosed again.
Okay.
It's just the certification.
Okay, thank you.
Representative Hawkins, Chairman Hawkins up the center aisle to your right is recognized for a question.
Thank you, Mr. Speaker. I'm trying to figure out your line numbering here. If you're dropping out 2 lines, which it appears to be arthritis and insomnia, wouldn't that affect your second by replacing lines 540? Shouldn't that read 2 lines less? I mean, I hate to say this, but it seems like we'd be on 538 to 540 in your second part of your amendment.
I believe since they had to go off the committee substitute that we sent them, the Ledge Council says that the way they did it was the correct way, that even though you're right, if we did the first part of the amendment first, then we'd have to change the second. We have to do a second amendment for the e-card because you're right, the lines would be different. But I think Ledge Council has said this is the correct way to go by the substitute that we sent them and get it done. But I appreciate the question.
Representative Al is recognized for a question to your left in the back.
Thank you. Does the gentleman yield?
Yes, ma'am.
Isn't it true that even with these changes from the Senate, that this is a good bill that's going to help more patients get access to our medical cannabis program while also offering more formulations for those patients?
Well, it is true. It does allow, as we voted on the other night, that to do delivery methods, which are different, changed it to milligrams, as we said, from a percentage basis. I do think it does 2 things, though. It does severely tighten up on the physicians, and both with the bill we just passed, Senate bill we just agreed to, or passed, I think that the attention to make sure that the physicians are there for their patients, they're not several states away, not available, that they'll do the annual reporting, that they will oversee their patients, they will pull out the ones that it's not appropriate for. That's just as important as making sure that the one that it's appropriate for are getting the right dosages and treatments. So, but thank you for that, ma'am.
Thank you. I look forward to voting yes on this again.
Gentleman has one final question. Representative Jasmine Clark to your left.
Yes, ma'am.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
So right now, how is severe insomnia treated?
Thank you for the question. Current Georgia cannabis law has no mention of severe insomnia. I will tell you, our special Blue Ribbon Study Committee did look at both hemp-based products that were out there as well as medical cannabis, and they're really 2 separate studies that we were doing. They obviously overlap, with THC being a significant component. It had been more anecdotal. There's evidence that hemp-based THC is not necessarily good in some people for insomnia, and it's good for others that report good relief. And all our insomnia medicines are really not that great for the right stage of sleep and combinations. So we on the committee had looked at that, and with me as the chair, I also thought it had some weight behind it, but that doesn't really comport with what we've decided as a body, that the right thing to do would have been to get to put that proposal in front of the combination of the Department of Public Health and the Georgia Medical Board and get an opinion from them first, as we did with lupus, which we are adding at this time. So I think we can go about it. It may take just a little bit longer, and we can look at the data and have those 2 bodies look at the data, and then we can move forward. But I think it's important that we move forward on this, hopefully soon.
Thank you.
Thank you.
Gentleman has
Speaker,
no
with
further
that-
questions.
I'll yield the will. I appreciate your support.
On the gentleman's motion that the House agree to the Senate amendment to the House substitute to Senate Bill 220, all those in favor will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machines. Have all members voted? All members voted. If so, Mr. Clerk will lock the machine. On Senate Bill 220, to agree to the Senate amendment to the House sub, the yeas are 144, the nays are 21. The House has agreed to the Senate amendment to the House substitute to Senate Bill 220. $441? Mr. Clerk, will you read the caption to Senate Bill 441?
Senate Bill 441 by Senator Harvin of the 16th and others to be entitled an act to amend Chapter 83 of Title 36 of the Official Code of Georgia Annotated relating to local government investment pool so as to require certain pooled investments to be approved by the State Depository Board. This bill having been referred to the Committee on Budget and Fiscal Affairs Oversight, that committee recommends that this bill do pass.
Representative Johnny Chastain is recognized to present Senate Bill 441.
I'm waiting. I was watching you. Thank you, Mr. Speaker. I rise today to present SB 441. This bill actually passed the Senate unanimously, also passed our Budget and Fiscal Oversight Committee here in the House unanimously last week. We have a local government investment pool here in Georgia now called the Georgia One Fund. It was created by the legislature 45 years ago, and it's been very successful. It has $72 billion in assets. It started out just for the local government agencies to deposit money into, and it was so successful they opened that up to the local governments. As of today, it has over 550 local governments that participate in this fund. It has strong oversight with the State Deposit Board. That's chaired by the governor, the state CFO, the OPB director, the state accounting officer, commissioner of banking and finance, the state revenue commissioner, the DOT commissioner, the state treasurer, and it has tremendous oversight to that fund, and I say it's been in existence for over 40 years. 441, all it does is ensures that any local government investment pool that might be created by the legislature in the future would be subject to approval of the State Depository Board. This will ensure the safety and soundness for any future pools that may be approved by the legislature. That's the bill, Mr. Speaker.
The gentleman has no questions.
Thank you.
Gentleman's yielded the well. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted. If so, Mr. Clerk. All members voted now. So, Mr. Clerk will lock the machine. On the passage of Senate Bill 441, the yeas are 167, the nays are 0. This bill having received the requisite constitutional majority is therefore passed. Mr. Clerk, will you read the caption to Senate Bill 428?
Senate Bill 428 by Senator Kirkpatrick of the 32nd and others, being entitled an act to amend Article 7 of Chapter 4, Title 49 of the official code of Georgia annotated relating to medical assistance generally, so as to direct the Department of Community Health to submit a waiver request to the Federal Centers for Medicare and Medicaid Services. This bill having been referred to the Committee on Health, that committee recommends that this bill do pass.
Leader F. Stration is recognized to present the bill. Leader F. Stration.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring to you Senate Bill 428. This bill is about addressing a need for Georgians who are sometimes overlooked. It's about Georgians with serious mental health needs who do not require institutional care, but who are still struggling every day without consistent support. These people who often cycle through hospital visits, emergency rooms, homelessness, or even incarceration, not because help does not exist, but because the right level of care for their mental health needs are not always available. Senate Bill 428 begins the process toward a better approach. This bill would direct the Department of Community Health to seek a federal waiver for home and community-based mental health services for eligible adults. This is very important because better access to care is not just about convenience, it's about outcomes for these patients. When people receive services earlier in time, we can help to stabilize their lives before they spiral into crisis. Additionally, we can reduce repeat hospitalizations and ease the burden on Georgia's emergency rooms. Most importantly, it gives individuals and their families some greater certainty as they care for their mental health needs. This ultimately is also a savings to Georgia taxpayers. It's with this in mind that I encourage your support of SB 428. Mr. Speaker, I'm happy to yield for any questions.
To your left, Chairman Petrie is recognized for a question.
Thank you, Mr. Speaker. Mr. Leader, do you yield?
Yes, sir, I do.
Mr. Leader, is it not true that Medicaid waivers like this are ways that states can seek to do things outside of the ordinary path to find innovative ways to solve problems in our medicated populations?
Yes,
Is
sir,
that not
absolutely.
true?
Our states are laboratories for our democracy where we can find efficiencies and greater patient support. Thank you for the question.
The gentleman has no further questions.
I yield the well.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All opposed to the passage of the bill will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted. If so, Mr. Clerk will lock the machine. On the passage of Senate Bill 428, the yeas are 166 and nays are 2. This bill, having received the requisite constitutional majority, is therefore passed. Representative Lisa Hagan is recognized for a motion.
Mr. Speaker, I make a motion that this body agree to the Senate substitute to House Bill 162.
Mr. Clerk, will you read the caption?
House Bill 162 by Representative Hagan and the 156 and others to be entitled an act to amend Chapter 3 of Title 35 of the Official Code of Georgia annotated relating to the Georgia Bureau of Investigation so as to provide for the restriction and seal of First Offender Act sentences until such status is revoked.
Chairlady Hagan is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. Colleagues, just to remind you, this is the bill that modernizes Georgia's First Offender Act. You were so supportive there. The change is simply in 2 spots, changing 2025 to 2026. And those are the changes, Mr. Speaker. And I ask for your ask for your agree vote on this substitute. Thank you.
Chairman Could you answer a question? I'm sorry. I thought he had some papers were on his button.
Sure.
Chairman Parsons is recognized for a question.
Thank you, Speaker. The lady yield?
Yes.
Well, first of all, I want to say how much I appreciate all the work you put into this. And is it not true that this code section you're dealing with is a very complex piece of work in here to try to even understand it to begin with what's already there?
Yes.
Is that not true?
That's true.
As I'm reading this, it looks like the first two sections, at least maybe the first three sections, just dealing with how the FBI can, not the FBI, but the GBI can, what information that they can release and who they can release it to, so on and so forth. And first offenders doesn't actually appear into it later on into, I think, around line 50 or 60, something like that. So I'll just make it short. My question is, with all that's been deleted and all that's been added, does this relate to anything, any offenses other than first offender?
No, it doesn't. And the First Offender Act already specifically defined what charges, what offenses were eligible to make a first offender plea, and none of that was changed in the bill. And furthermore, even if they're eligible to make a first offender plea, the judge had the discretion all along whether or not they would accept that plea. That did not change in this bill at all. The only thing that changed from the bill that we passed unanimously last year is just those dates.
Okay. Thank you very much. Appreciate your work.
Thank you, Mr. Speaker. I ask for your agree vote on this substitute.
Ladies yield to the well. On the lady's motion that the House agree to the Senate substitute to House Bill 162, all those in favor will vote yes. Those opposed will vote no, and Mr. Clerk will unlock the machines. Have all members voted? All members voted? If so, Mr. Clerk will lock the machine. On the lady's motion, the yeas are 166 and nays are 0, and the House has agreed to the Senate substitute to House Bill 162. Mr. Clerk, will you read the caption to Senate Bill 485?
Senate Bill 485 by Senator Payne to the 54th to be entitled an act to amend Article 1 of Chapter 10A of Title 43 of the Official Code of Georgia Annotated relating to examination regarding professional counselors, social workers, and marriage and family therapists. So as authorize applicants for a license enrolled in a master's degree program to take the master's social work licensing examination in their final semester. This bill has been referred to the Committee on Regulated Industries. That committee recommends that this bill do pass by committee substitute.
Chairman Powell is recognized to present Senate Bill 485. Senate Bill 485.
Thank you, Mr. Speaker, and ladies and gentlemen. Pretty straightforward and a simple bill. It's got two sections into it. Nail techs on July the 1st or thereafter, nail techs will have to produce a copy of their real ID for applications and renewals and to keep a copy on the place of business. And secondly, for those students who are taking a master's program in counseling, that they'll be able to take their state exam in that last semester before they actually graduate from the course, so they can get on forward. Also, one last thing, it does, the certifying entity has got to be a member, has got to be a nonprofit organization. And that's quite simply the simplest bill I've done this session, and we know how good I am about marriage therapy.
Well, I do know that. So,
I'd be more than glad to answer any questions. And if not...
Representative, you have a couple of questions. Representative Rahman up the center aisle to your left is recognized for a question.
Does the gentleman yield?
Yes, ma'am.
So it seems that there is a requirement in this bill as it pertains to driver's licenses and essentially posting up the driver's licenses. Can you explain why that was put in there or who asked for it?
I cannot tell you. It came up in the committee as an amendment that nail techs should show their IDs before they renew or go through a process of licensing to be a nail tech and keep a copy on file. I'm only suspecting it was for the to do a background check for public health risk.
Does the gentleman further yield?
I certainly will.
So I'm actually looking for lines right now. I'm sorry, I'm like talking to you as I'm looking this up. But when we talk about these like driver's licenses and the information that they provide, including for the patrons, isn't there a concern that a customer is asking for more details than they need about their nail tech, which could then open them up for things like fraud and identity theft?
I wouldn't think so. I mean, you're saying that show your ID. You have to show your ID for just virtually every license you take today. You do it on transfer of property. You do it on all licenses. But this is basically saying show your license and keep a copy on file. Not on the wall, but on file.
Representative Rhonda Taylor, to your left, is recognized for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Can you explain why there is a specific portion of this bill that requires real ID for nail technicians and their apprentices? Why that was added to the bill?
The only thing I can explain is it was an amendment that was put forth in the committee, and the committee voted for it.
I'm sorry, I couldn't hear you.
It was put forth in the committee as an amendment, and it was amended by the committee.
Over in the House side or in the Senate?
In the House side.
In the House side. Can you, does the gentleman further yield?
Certainly.
Can you please direct me to who added that so that I can get a better understanding, please?
You know, I don't know. This came out of the committee a couple of weeks ago, and I'm not sure which member submitted this.
But it wasn't added then, was it? No, it wasn't in there. The original bill did not have that
Not
language.
in the original, as an amendment in the committee.
Right.
Yeah.
I'm just wondering which one of our legislators added this amendment.
I do not know which member. It was there that day when we had a meeting, and it was offered as an amendment.
Okay, thank you.
Yes, ma'am. Mr. Speaker, if there's no further questions, I would appreciate your favorable consideration and appreciate your vote. And I'll yield the well.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to adopting the committee's substitute? Hearing none, the committee's substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? For what purpose Representative Clark rise? Representative Jasmine Clark.
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Is it not true that I had a question for the presenter of the bill about the section dealing with the Masters of Social Work? And what I wanted to know was what assurances do we have that the person who takes the exam has actually passed their course, since they are actually taking the exam before they pass they actually get the degree?
Thank you. Does the gentleman have a parliamentary inquiry to answer that?
Yes, sir. Yes, sir, Mr. Speaker.
For what purpose does Chairman Powell rise then?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, is it not true that these students that are working on a master's degree that can stand for the test in their last semester, both the testing officials and the school has to certify that they're in that last semester of their studies at that school?
That doesn't answer my question. All right. All right.
So the student has to apply for their license post-graduation. So it all has to travel together to the Secretary of State's office that is proof of their graduation and their licensure.
Thank you, Mr. Speaker.
Thanks to both of the members for clarifying that. Have all members voted? If so, Mr. Clerk will lock the machine. On the passage of Senate Bill 485, the yeas are 121, the nays are 46. This bill, having received the requisite constitutional majority, is therefore passed. Representative Leverett is recognized to make a motion.
Thank you, Mr. Speaker. I move that the House agree to the Senate amendment to House Bill 999 as amended by the House.
The gentleman moves that the House agree to the Senate amendment to House Bill 999 as amended by the House. Mr. Clerk will read the caption.
House Bill 999 by Representative Leverett of the 123rd and others, be entitled an act to amend Article 5 of Chapter 10 and Title 15 of the Official Code of Georgia Annotated relating to fees and costs of magistrate courts, so as revised provisions related to magistrate courts collecting sums and fees authorized by law.
Chairman Leverett is recognized to explain the actions of the Senate.
Thank you, Mr. Speaker. Ladies and gentlemen, House Bill 999 was a bill that implemented some changes with respect to magistrate courts. It would allow them to assess additional fees besides what was set out in statute if there was a local act authorizing it. We also fixed some repealer language in the bill last year that provided for nonpartisan election of magistrate court and probate court. The Senate has added an initiative here to increase the jurisdictional limit of magistrate courts. In the Senate, that was increased from 15,000 to 30,000. We are leaving that policy in, but we're just reducing the increase. So instead of from 15,000, it would go to 25,000. And we're also providing that the increase in the jurisdictional limit won't take effect until January. That's been requested by the magistrate judges themselves who support this. They support the increase at this level, and also the defense bar and other constituencies support making the change that we are if you approve this amendment today. Mr. Speaker, I'll stand for any questions. I know it's exciting stuff.
Representative Ramon, to your left of the center aisle, is recognized for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Can you just clarify the LC number, please?
We didn't get, I think, an LC from the Senate. It was the original bill. They amended it, and there should be an amendment that's 2 pages on your desk. One of them was correcting a typographical error. The other is Senator Setzler's amendment adding the change in the jurisdictional limit. And then our proposed amendment to that is AM 470192. All those should be on your desk with the original bill.
Jim will yield for one more question. Representative
sir, I'll
Jasmine
yield.
Clark, to your left.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
So I just want to make sure I know what I'm voting on. The 2-page paper says does not exceed 30,000, but the 1-page thing with your name on the top says 25,000. In your presentation, you said 25,000. Are we voting for 25,000 or 30,000?
We're voting for 25,000 to increase from 15,000, which is the current limit, to 25,000.
So this 2-page one is before the AM 470192.
That is correct.
All right,
That is
thank
correct.
you.
The 2-page paper was the action taken in the Senate. This is the action we would take today.
We are taking today. Thank you.
Representative Derek Jackson, recognized for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
So based on that 25,000, is that a market value? How did you come up with 25,000?
Well, 25,000 is just it's more gradual increase, first of all. And I think that is a number that is supported by the Magistrate Judges Council as well as folks who practice in the defense area in motor vehicle accident, because that's the minimum limits on most insurance.
Okay. Thank you.
The gentleman has no further questions.
Thank you. Thank you, ladies and gentlemen. I would ask your favorable consideration of the motion.
Members will adopt the House amendment first, if that's your wish. Is there any objection to the adoption of the House amendment? Hearing none, the House amendment is adopted. On the gentleman's motion, the House agreed to the Senate amendment to House Bill 999 as amended by the House. All those in favor will vote yes. Those opposed will vote no. And Mr. Clerk will unlock the machines. Have all members voted? All members. It is nap time. Have all members voted? If so, Mr. Clerk will lock the machine. On the gentleman's motion, the yeas are 167, the nays are 0, and the House has agreed to the Senate amendment. The House has agreed to the Senate amendment on House Bill 999 as amended by the House. Mr. Clerk, will you read the caption of Senate Bill 500?
Senate Bill 500 by Senator Hodges III and others to be entitled an act to amend Chapter 10 and Title 49 of the Official Code of Georgia annotated relating to the Georgia Board of Health Care Workforce so as to expand the Behavioral Health Care Workforce database. This bill having referred to the Committee on Public and Community Health. That committee recommends that this bill do pass by committee substitute.
Representative Rick Townsend is recognized to present Senate Bill 500.
Thank you, Mr. Speaker. SB 500 is a workforce bill for health care. It expands the behavioral health care database and includes licensed health care professionals. It's regulated by the licensing boards. It started off having 5 boards participating. Now 15 boards will participate. Each respective board shall create and maintain a health care workforce database. Mr. Speaker, it's got a few extra details. Basically, they're going to work with the governor, the House, and the Senate, and state agencies for this database. They'll seek outside funding as well, such as federal funds and grants, and create an online dashboard accessible for the board's website to provide. And Mr. Speaker, that is the main parts of the bill. Yield for any questions.
Gentleman does have a question. Representative Lisa Campbell, to your left, is recognized for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am.
Thank you. I'm curious to understand, it's a pretty simple bill for a pretty large database, and you mentioned that on lines 43 that we can seek sources of funding. Is that another way of saying that we do not have allocated funding in our budget to implement this?
Not to my knowledge, no. To my knowledge. Basically, that's what's going to, that's what I understand, yes.
Does the gentleman further yield?
Sure.
Well, let me pose it another way. Do we have allocated funding in our 2027 budget to implement this database?
From my understanding, yes, we do. This will be carried out.
Thank you.
Gentleman has no further questions.
I yield the well.
Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to adopting the committee substitute? Hearing none, the committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted. If so, Mr. Clerk will lock the machine. On the passage of Senate Bill 500, the yeas are 164, the nay is 1. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to Senate Bill 542, 542?
Senate Bill 542 by Senator Robertson of the 29th and others, being entitled an act to amend Chapter 6 and Title 16 of the official code of Georgia annotated relating to sexual offenses so as to permit clergy members to be charged with certain improper sexual contact offenses. This bill having referred to the Committee on Judiciary, that committee recommends that this bill do pass by committee substitute.
We have a couple of speakers on this bill as well as Leader F. Stration, who will present the bill. The leader is recognized to present Senate Bill 542.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring to you SB 542. This legislation is about protecting individuals who seek out, in places of faith or in meeting with a trusted leader in faith, comfort, guidance, and healing, who are instead, when they're seeking out that religious direction, face manipulation, coercion, and betrayal. This is about survivors who carry the weight after this coercion, often in silence, and are impacted by what they've been through for years to come, who are unsure if the law will ever recognize that what they have been subjected to should be called out and should be punished, even criminally. As I begin today, I want to take a moment to thank the survivors and the advocates who have worked so very hard on SB 542. Some of them are in the gallery and others are watching online, but we have with us Kim Nunes, Haley Swinson, Ruth Malhotra, Chuck Wills, and there are so many others who have actively worked on passing this legislation. I want to say this clearly to the survivors out there who are following this bill. We see you, we hear you, and today the General Assembly has an opportunity to act on your behalf to ensure that others are better protected in the future. Clergy members occupy one of the most trusted roles in our society. They're invited into hospital rooms, counseling rooms. They work with those who are suffering with moments of grief, sense of loss, maybe uncertainty about their future, and are needing help, are needing moral direction from these individuals that we put in such high regard in our society. These people also, in these trusted roles, have great influence over those that they are counseling and those that they are directing. They operate in a relationship which is built on trust, and it's one in which there is naturally a form of influence over the person who's receiving that help. When someone sits across from a clergy member in a moment of vulnerability, this is not an equal exchange. It's a relationship where one person holds power, moral authority, and emotional influence over the other. And when that power is used to exploit, manipulate, coerce, or harm, it's not just a physical harm that's being created. It can also be an emotional and a spiritual harm that that victim will carry long term. Senate Bill 542 will change all this. This bill will allow in the law clear and necessary boundaries, which establishes that when a clergy member uses his or her undue influence, uses the position for the purposes of coercion, deception, intimidation, within that pastoral relationship, to ultimately engage in sexual contact, That is not a consenting situation. That is the person using that authority that they have in that position for an improper purpose. And that's why this legislation is so important. Similarly to criminal offenses that we have for other positions where one person is in a superior position in the relationship and where coercion or even a lack of consent is just not possible. Or to protect individuals, I should have said, from coercion in those circumstances. Ultimately, this legislation is important because it allows survivors the opportunity to go to law enforcement to express what has occurred, but also can deter this type of criminal conduct now from even occurring on the front end, thereby protecting those who would otherwise be vulnerable. It's for all these reasons that I encourage your support of Senate Bill 542. And Mr. Speaker, I'm happy to yield for questions.
Gentleman has a couple of questions, if he'd yield.
Yes, sir, I'll yield.
Thank you for your presentation. Representative Al Williams to your left is recognized for a question.
Thank you, Mr. Speaker. Will the gentleman yield?
Yes, sir, I will.
Is it not true that clergy, regardless to religion or denomination, are held in the highest possible moral stature in this country?
Yes, sir, that is true.
Is it not further true that anyone that breaks this trust does not deserve to be in the position of ever hurting anyone again?
Yes, sir, the gentleman is absolutely correct. And to have in our criminal code also the standard with which that coercion, authority position being used improperly will be helpful for prosecutors evaluating this case and to protect other potential victims, as you outlined.
Will the gentleman further yield?
Yes, sir.
It's a good piece of legislation. Thank you for bringing it.
Thank you very much.
Representative Carlton Howard to your left in the back is recognized for a question.
Thank you. Thank you, Mr. Leader. Does the gentleman yield?
Yes, sir.
A perfect bill. I appreciate the bill as well. When it comes to in the bill, when it relates to false accusations, is there anything in the bill that addresses that?
Yes, sir. Well, similar to an evaluator that a prosecutor must make in determining these types of crimes, the statement that's provided by witnesses and the other evidence has to be evaluated to ensure that there is not false allegations that ultimately lead to a prosecution or conviction. Now, I'll just say that this is something prosecutors, as a former prosecutor myself, am very familiar with dealing with. You have to make those types of evaluations really case by case to ensure that the evidence is reliable before it's formally accused through a bill of indictment and brought before a jury at trial. Thank you for the question.
You have one last question, Representative Teddy Reese to your left in the back.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Would you agree that when an individual is in a place where they're practicing their faith and the space where they are at their highest level of vulnerability, those individuals should be in a space where they're protected and not preyed upon by individuals that seek opportunity to take advantage of them during that time and circumstance?
I completely agree with the gentleman, and I would just say when a person enters a house of worship, when a person seeks out an individual serving in a pastoral role, they're doing so in a position of need. They're doing so seeking direction, and often that occurs, particularly when they're in a position of real vulnerability and susceptible or more susceptible to somebody who may try to take advantage of the situation. Yes, sir.
And I want to thank the gentleman for bringing this bill, and I fully support it.
Yes, sir. Thank you very much. Mr. Speaker, I'll yield the well, and I'd ask for the body's favorable consideration of this very important measure. Thank you.
The gentleman's yielded well. Thank you for bringing the bill. We have two folks who want to speak in favor of the bill. We're going to allocate 15 minutes, but we'll be liberal on that if you need more. So I'm going to recognize Representative Stacey Evans first to speak to the bill. If y'all can allocate that time between you, that'd be great, but we will not shortchange. Ladies recognized.
Thank you, Mr. Speaker. Good afternoon, ladies and gentlemen. I rise in strong support of Senate Bill 542. I think this bill provides us an opportunity to do and hear what we came here to do. Find a hole in the law that's really hurting real people day in and day out and fix it. That's what we get to do today. And I'm really proud of us in the Judiciary Committee. We looked at this bill which will criminalize the activities of monsters who don't deserve our sympathy or our remorse, but we took a strong and level hand to make sure that we made the definitions tight, that we weren't being overbroad, that we weren't bringing people into the criminal system that didn't deserve to be there. And that took a long time, as we tend to do in judiciary, and I think we've got a great product here. What I wanted to do today is to highlight some of the voices of the survivors and of the advocates, because those of us in the committee got to hear those voices, but I think it's important for us in this body to hear them too, because that's why we're here, to help them and others who we hope will not have to trod the path that they did. And I want you to hear what we heard, and I'm going to do some snippets here. But first, a survivor, Haley Swinson, who told us, adult clergy sexual abuse is real. It does not begin with force. It begins with trust placed in a spiritual authority figure. In my experience, what began as a spiritual guidance became years of manipulation, isolation, and sexual exploitation, framed as something I was told to trust as being from God. Scripture was twisted from Genesis to Revelation to convince me that this was God's will. Authority used to groom, boundaries slowly eroded, and what felt violating was reframed as obedience. She said, this is not consent, this is coercion through power. In my case, in Haley's case, it took 35 journalists and publications to shine light on the darkness because there was no clear legal path to justice or accountability. And this is what we can do something about today, ladies and gentlemen. From Chuck Willis, another survivor of clergy abuse, from his words, the person who abused me didn't come to me as a stranger. He came to me as someone I was taught to trust, a spiritual authority, a leader. When someone holds that kind of authority over you, it changes everything. It changes how you understand right and wrong. It changes what you feel allowed you to say no. It changes whether you even recognize what's happening as abuse. What happened to me was not just misconduct, it was the abuse of authority. This bill is not about attacking faith, he said. This is about protecting people from those who would use faith as a tool to harm. We heard from experts in the field, Dr. Holly Haynes, who holds a doctorate from Harvard University in human development and psychology and has provided a scientific context for the harm described by the survivors. This is her quote, "The science is unequivocal. Clergy sexual abuse inflicts a category of harm that Georgia law does not yet recognize and must. Survivors are robbed of their relationship with God. They are robbed of their relationship with God. They are estranged from the communities and practices that once gave their lives meaning. The power differential here is not just professional, it is perceived as divine. Clergy are believed to speak for God and to hold authority over the soul itself. When that authority is used to exploit, the survivor does not just lose trust in one person, they can lose their entire framework for understanding the world. Because of the shame and the spiritual confusion that accompanies this betrayal, they are the least likely to come forward and the most in need of legal protection. The science supports it, and the survivors deserve it. Ladies and gentlemen, let's join together and pass Senate Bill 542. Thank you, Mr. Speaker. I yield the well.
Thank you, Representative. Representative Scott Hilton, Chairman Hilton is recognized to speak in favor of the bill. The gentleman is recognized.
Thank you, Mr. Speaker. Leader Efstration did a fantastic job walking us through the bill. Representative Evans did an even better job of amplifying the voices of those victims here. I rise today in full support of the legislation to highlight one specific voice, a constituent and very good friend of mine who's up in the gallery right now, Kim Nunez, and to tell her story. Kim approached me about a year ago, and just like you, I serve some of the brightest and most courageous people in all of the state. And Kim came to me to share her story, and I'm honored to share it here with you today. She is a whistleblower and an advocate that has demonstrated extraordinary courage. After more than a decade of working in a faith-based organization, she came forward when she discovered what was first described as an inappropriate relationship. but was later to be revealed to be a long-standing pattern of manipulation, coercion, and abuse. And Kim did what we hope anyone would do. Kim spoke up. But instead of immediate accountability, she encountered resistance, networks that protected the abuser, and a system that in so many ways was not equipped to respond. Through that experience, Kim helped shine a light and a gap in our law. And she is part of the reason we are here this afternoon. Senate Bill 542 is not about targeting the faith community, it's about protecting it. It's about ensuring that those who lead with integrity are not overshadowed by those who abuse their position. And most importantly, it's about standing up for victims, many who have gone unheard for way too long. I'm grateful for Kim and all the victims and advocates who've spoken up. You're the reason we're here today, and you are making change. You are protecting current victims and those in the future. Thank you for your courage. Mr. Speaker, colleagues, I ask for your full support of Senate Bill 542. Thank you. I yield the well.
The gentleman has yielded the well. That concludes our discussion on Senate Bill 542. Is there any objection to the previous question being ordered? Hearing none, the previous question is ordered. Is there any objection to adopting the committee's substitute? Hearing none, the committee's substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and Mr. Clerk will unlock the machine. Have all members voted? For what purpose does Representative Sanchez rise?
Parliamentary inquiry.
State your inquiry.
Isn't it true that we are very proud and very glad to have survivors here with us here today, and also those who are not here with us, for their courage and their advocacy on this issue?
The gentleman knows of what he speaks. We sure are. And we're going to welcome here to the House in just a minute. For what purpose does Representative Parrish rise?
Parliamentary inquiry.
State your inquiry.
Thank you, Mr. Speaker. Is it not a sad day that this Georgia House has to pause from the people's work to address the criminal misbehavior of those supposedly led by God?
Well, I understand what you're saying, but I think it's a good day that we take care of the business of the people of this state to make sure they're safe and provide penalties when those abuse that privilege. For what purpose does Chair Lady Mathiak rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that this very well could be a great step for healing for our victims of Georgia?
I think the lady knows of what she speaks, and I hope the actions of this day will accomplish some of just that. Have all members now voted? If so, Mr. Clerk will lock the machine. On the passage of Senate Bill 542, the yeas are 168, the nays are 0. The bill having received the requisite constitutional majority is therefore passed. Y'all stand. Thank you for your courage, and know that this House stands with you. Thank you for being here with us, and thank you for encouraging us to do the right thing. Thank you so much. God bless you all. Chairman Prince is recognized for a motion.
Thank you, Mr. Speaker. I move that the House agree to the Senate substitute to House Bill 483.
Mr. Clerk will read the caption.
House Bill 483 by Representative Prince of the 132nd and others, be titled an act to amend Article 2, Chapter 5 of Title 16 of the Official Code of Georgia annotated relating to assault and battery so as to provide for protections for inspectors of code enforcement.
Chairman Prince is recognized to explain the Senate substitute.
Thank you, Mr. Speaker. House Bill 483 provides protection for code enforcement officers when they're conducting their duties. The Senate made a couple of changes starting around line 13. They basically changed it from enforcement officers to code enforcement officials. Also in line 13, they added the high school diploma or equivalent. And then the other change they made was on, of course, line 92, changing the effective date from July 2025 to July 2026. Mr. Speaker, that's the bill, and I stand for any questions.
Gentleman has no questions.
I yield the will.
On the gentleman's motion that the House agree to the Senate substitute to House Bill 483, all those in favor will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machines. Have all members voted? All members voted. If so, Mr. Clerk will lock the machine. On the gentleman's motion, the yeas are 140, the nays are 26, and the House has agreed to the Senate substitute to House Bill 483. Mr. Clerk, will you read the caption to Senate Bill 443?
Senate Bill 443 by Senator Summers of the 13th and others to be entitled an act to amend Article 2, Chapter 11 and Title 16 of the Official Code of Georgia Annotated relating to offenses against public order so as to increase the punishment for the offense of obstructing highways, streets, sidewalks, or other public passages. This bill I refer to the Committee on Judiciary and Non-Civil. That committee recommends that this bill do pass.
Before I recognize Representative Noel Williams to speak to the bill, so y'all can be determining your comments. We have 5 members that have signed up that want to speak in opposition to the bill. We want to allocate 15 minutes for those of you to speak against the bill, or as much of that as you want, and you will allocate that amongst yourselves. And we also have speakers in favor of the bill. You'll also have the same amount of time. So I'm going to recognize Chairman Noel Williams to speak to the bill. Representative Williams.
Thank you, Mr. Speaker. I come before you today with Senate Bill 443. Basically, it's a protection bill for the Georgians. This stops streets from being blocked and bridges and no public access when they're crisis. This would cause a highly aggravated misdemeanor, which could be up to about 12 months in jail or up to a $5,000 penalty for anyone who purposefully or recklessly obstructs any highway or street in such a way to render it impassable, or causes hazard or fails or refuses to remove the obstruction after a reasonable official request has been made. In addition to any other fine or penalty or restitution which may be imposed by law, such person may be held civilly liable for damages that result from an offense of this code section. Basically, all we're trying to do is protect our citizens. You think about, mothers trying to pick their kids up from work. You think about ambulances trying to get through. You think about people in need, and they're obstructed from getting to their place of action. Mr. Speaker, it's a simple bill. It's a common sense bill for the people of Georgia. I think we should all vote green in accordance with this, and I know there are a few more speakers, so I'm going to...
You have a question if you'll take one from
I'll take one question.
Peter Hughley, right in front of you, and then we'll move on to the discussion.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, ma'am, I certainly do.
Isn't it true that you just said about we need to think about mothers trying to pick up children and yada, yada, yada?
I didn't say yada, 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 no ma'am.
But what I think about is what would have happened on the Edmund Pettus Bridge if this bill was in place? What would have happened for the March on Washington? What would have happened for all of those protests that allowed me to be here today if this bill had been in effect? Thank you.
Well, I think there's been a lot of progress that has been made since that happened, and I think we need to look forward and go forward instead of look behind. But I appreciate your question. I yield the well, Mr. Speaker.
Gentlemen, is yielded the well. This will be the Representative Drenner, Representative Park Cannon, Representative Sanchez, Representative Berry, and Representative Wafer Baker. Will be the order that you will be recognized. Representative Drenner, ladies recognized.
Thank you, Mr. Speaker. I rise in opposition to Senate Bill 443. My concern with this bill is very specific. It is the civil liability provision. This bill does more than create a criminal penalty. It allows individuals to be sued for damages connected to a protest. That means someone could face financial liability for lost wages, medical costs, or other claims simply for being present. And that is the issue, because the most powerful deterrent to protest is not a misdemeanor. It is the threat of financial ruin. When people know that participating could expose them to lawsuits, many will choose not to show up at all. That is not about managing behavior after the fact. That is about stopping participation before it begins. Civil liability changes the nature of the right itself. It turns a constitutional right into a financial risk calculation. And that is a line we should be very careful about crossing. For that reason, I cannot support this bill, and I urge a no vote on Senate Bill 443. Thank you, Mr. Speaker. I yield the well.
Ladies yielded the well. Representative Park Cannon, you're recognized to speak to the bill.
Thank you, Mr. Speaker. Good afternoon, my colleagues. I rise today in opposition to Senate Bill 443. Let me begin where we all agree that public safety matters and that order matters. Here in this chamber, we are guarded by police and we have rules on decorum. No one in this chamber is advocating for unsafe roads or blocked emergency vehicles. That is not the issue before us. The question is whether and how far this bill can go. It is trying to solve perhaps one problem, but is creating a deeper harm for the people we represent. In practice, this bill is not just about traffic enforcement, it's about protest and who pays the price for participating in it. This bill raises the penalty for obstructing a roadway in a high and aggravated misdemeanor and opens the door to civil liability. That may sound like a technical change, but for many Georgians, it's life-changing, and it will not change lives of everyone equally. For low and middle-income constituents, this bill could be devastating. Higher fines, potential jail time, and a permanent criminal record can mean lost jobs, missed rent, and long-term financial instability. For a family already living paycheck to paycheck, one charge like this is not a minor inconvenience, it's a crisis. And when you add the possibility of civil lawsuits, the risk becomes even greater. A person could be sued for simply being a part of a protest that disrupted traffic, even if they were peaceful, even if they caused no harm. Most families work and cannot afford to defend themselves in court, and the threat alone is enough to silence them. So let's continue to talk about who this really impacts. Think about workers protesting for fair wages, for safer conditions, or the right to organize. Historically, labor movements have relied on public demonstrations, sometimes disruptive ones, to bring attention to injustice. Under this bill, a worker standing in the street to demand fair treatment could face not just arrest, but also criminal penalties. It tells working people, speak up if you want, but be prepared to risk your livelihood to do it. It's not just labor. As I close, I will say this particularly today impacts the people in social circle. The people right now represented by people who are not even in the chamber, not even listening, but who are protesting ICE creating a new facility in Georgia. So I ask yourselves, is it really important that we pass this today? Please vote no.
Representative Sanchez, gentleman's recognized. Representative Berry, you're next.
Thank you, Mr. Speaker. I rise to oppose Senate Bill 443, which raises the grade of offense for blocking of a public street to a high and aggravated misdemeanor, which means it imposes higher penalties and jail time. It is written like a harsh crackdown on jaywalking, but it really has nothing to do with public safety. All this does is attack the First Amendment. The state of Georgia has been very consistent on this tactic, finding any legal avenue to stifle free speech of its own people the moment they challenge the status quo. When the state cannot find an avenue, we invent one, like this bill. Georgia tried this move very recently against the Stop Cop City movement. The AG prosecuted 61 organizers on RICO charges. And it was obvious from the get-go that these were bogus charges only intended to chill political speech that the state deemed too dangerous for the people to hear. There was no legitimate reason to go after protesters, especially in light of the fact that the real violence came not from the protesters, but from the state who murdered an innocent protester named Tortuguita, who to this day, no one has been held accountable for their murder. Every single one of those 61 RICO charges were dismissed by a judge because he knew, just like the rest of us, that these were bogus charges from the beginning. This judge is quoted as saying, litter on a state road, get prosecuted by the AG. Open container of alcohol at a Bulldogs game, get prosecuted by the AG. He was warning us of overreach by our government. Overreach to chill political speech the majority disagrees with. Now we're trying to go even further with Senate Bill 443. This is a transparent attempt to criminalize advocacy and weaken democracy. ICE is killing our neighbors. Police are arresting women on murder charges for taking an abortion pill. Our president wages an illegal war overseas, and Congress carries on protecting the Epstein class. Of course, people are taking to the streets. That's how democracies function. The most important time to hold on to democratic principles is when you disagree with someone. We talk about that all the time in this chamber amongst each other, but apparently we cannot extend that to the people. What a shame. Instead of using our power to fight for working people who are struggling to afford rent or buy groceries, y'all want to punish those same people for protesting a government that is not serving them. We will continue to fight corruption and oppression until this government actually represents the people. I urge you all to vote against Senate Bill 443. Thank you. I yield the well.
Gentleman's yielded. We have Representative Berry. Gentleman's recognized.
Thank you, Mr. Speaker. I rise today also in strong opposition to Senate Bill 443. So I'd like us to be really honest about what this bill is and what it is not. It's not about public safety. It's not about filling a gap in the law, because the truth is, obstruction is already a crime in Georgia. If someone blocks a roadway today, law enforcement already has the authority to respond, to cite, and to arrest if necessary. So the real question we should be asking is, what are we actually trying to do here? Because when you take an existing misdemeanor and escalate it to a high and aggravated charge, when you start layering on felony penalties, when you open the door to civil lawsuits, what you're doing is not fixing a problem, you're sending a message. And that message is simple. We don't want you to protest. But I have to ask, what are we so afraid of? Are we afraid of people gathering in the streets to demand better health care? Are we afraid of workers calling for fair wages? Are we afraid of people protesting policies that empower agencies like ICE, separating families and detaining folks with little accountability? Are we afraid of young people, many of them in our own districts, raising their voices about the future that we are inheriting? Because protest has never been convenient. It has never been comfortable. It has never been quiet. And it's not supposed to be. That's the whole premise of protest. From the streets of Selma to the communities right here in Georgia, protest is how people without power force this body and bodies like us to listen. And now we're saying that if protest is too visible, too disruptive, too effective, we're going to hit you with harsher charges, bigger fines, and threats of years behind bars. That is not public safety. That is deterrence by intimidation. This is unnecessary. Again, obstruction is already illegal. If the concern is safety, we already have the tools on the books. If the concern is emergency access, that is already addressed in current law. So why go further? Because the right to protest is not a Democratic right or a Republican right. It is an American right. Because this is bigger than a bill. This is about who we are. Today, it might be people used by people who you disagree with. Tomorrow, it could be your own constituents. It could be your community. It could be the very people who sent us here. And once you start criminalizing protests at this level, you don't get to pick and choose who it applies to. So, if someone breaks the law, we already have the laws to address it. But what they're really guilty of is being heard, then this bill goes too far. We should not be in the business of punishing people who simply because they make us uncomfortable. We should be in the business of listening. I urge a no vote. Thank you, Mr. Speaker. I yield the well.
Gentlemen, yield the will. Representing Wayford Baker. Ladies recognized.
Thank you, Mr. Speaker, for the opportunity today to be heard. I stand here not just as a member of this body, but as a criminal defense attorney. And I want to talk about a part of this bill that isn't getting the headlines. The criminal enhancement is what people are focused on, but the criminal piece is not the most dangerous part of SB 443. The civil liability provision is. And here is what it does. Anyone who is inconvenienced by an obstruction of a public passage, anyone who claims medical expenses, lost wages, or economic harm can sue the people responsible. That includes protest organizers, that includes individual participants. So one protest equals unlimited plaintiffs. And think about what that means in practice. A demonstration moves down a city block. It slows traffic for maybe 20 minutes. And in those 20 minutes, 100 people are inconvenienced. Maybe someone then is going to miss a meeting. Maybe one of them will claim a stress-related medical issue. And under this bill, every single one of them has a potential cause of action against the organizers. And you don't have to win a civil lawsuit to destroy someone. All you have to do is file it. Discovery alone, the depositions, the document requests, the subpoenas can cost tens of thousands of dollars to defend. So for a community organizer, for a nonprofit, for a church group that helped coordinate a march, that exposure isn't a legal risk, it's an existential threat. And this is not hypothetical. We have watched the mechanisms play out in context. The use of civil litigation as a cudgel against activists and advocacy organizations. The goal is not to win in court. The goal is to drain resources, consume time, create fear, and make the cost of organizing so high that people will stop doing it. SB 443 hands that mechanism directly to anyone with a grudge or an attorney. The criminal upgrade in this bill would deter some people. The civil liability provision will deter everyone else. It will deter the organizers who do the advanced planning because they have the highest exposure. It will deter the nonprofits who provide logistical support because they have assets to lose. It will deter the people who have families and mortgages and can't afford to spend 2 years in civil litigation over a 20-minute demonstration. That is the chilling effect of SB 443, and it is disguised to function exactly that way. If this bill were truly about traffic safety, the remedy would be fines. It would be court-ordered cleanup. It would be graduated penalties tied to actual harm. What it would not be is an open-ended private right of action with no cap on damages and no clear standard for what qualifies as payback harm. The civil liability provision has nothing to do with keeping road clears. It has everything to do with making protest financially unsurvivable. I urge this body to strip that provision from this bill at minimum and to reject the bill in full. Thank you, Mr. Speaker. I yield the well.
Ladies yielded the well. Now we have a couple of folks who signed up to speak in favor of the bill. They'll have allocated that same amount of time or less, whatever suits them. So we'll recognize Representative Jenny Earhart to speak to the bill. Representative Earhart. Y'all will have up to 15 minutes between the two of you. Ladies recognized.
Thank you, Mr. Speaker. Members, there's so many folks in this chamber that I respect on both sides of the aisle. A member of Minority Party was speaking to a bill earlier, just a little while ago, and said one of the purposes of this body is to find a hole in the law that's hurting people and fix it. And I couldn't agree more. I think that's exactly what Senate Bill 443 does. But I ask you, are we really here again? With some members of this body presenting the indefensible argument that obstructing Georgia roadways isn't harmful for Georgians? I ask you, how do you justify that to your constituents? What do you say to them? Sorry, neighbor, but your heart attack's gonna need to wait a while because we've got a roving band of 17-year-olds with their newfound enlightenment that need to lay down in the road. And we want to encourage that. Folks, the right thing to do is often the easiest thing to do. This bill makes absolute common sense. If you think folks aren't hurt by obstructed roadways in Georgia, I would ask you to consider the facts. There are 20 million Americans per year that participate in ambulance transports to hospitals with a host of physical dilemmas, emergencies, ailments. They depend on roadways that are free of impediment. They count on it. If you don't think voting for safe roadways in Georgia that are unobstructed by illegal actions is important, and you don't think you want to do something because it's the right thing to do, then maybe you'll do it for Alvin Henry Jones. He collapsed with breathing issues and later died after paramedics could not reach him in time due to roads blocked by protesters. Should have been a 5-minute drive to his local hospital. It took them 35 minutes because they had to reroute. If you won't do it because it's the right thing to do, maybe you'll do it for Richard McGrath. He's an 83-year-old car crash victim whose ambulance could not reach the level 1 trauma center he needed due to protester-blocked roads, but instead had to divert to a less equipped facility where he later died. If you won't do it because it's the right thing to do, maybe you'll do it for the protesters themselves. How about Summer Taylor, who was killed by a driver during a protest that blocked a freeway? She was encouraged to participate in that roadblock. How about Diaz Love, who was also killed on the same day as a result of protesters blocking that roadway? If you won't do it for them, maybe you'll do it for the 20 million individuals who depend on free roadways to complete a safe journey to the hospital or medical facility each year in the US. You know, the ones I'm talking about. The ones who trust that they will arrive safely and without impediment to receive the care that they need. I was listening carefully to some members that were speaking from the other side of the aisle on this bill, and I appreciate the passion. I heard one member say that civil penalties, more so than criminal penalties, are what people are fearful of, as if that is a bad thing. It's called a deterrent. We use it in this country to dissuade, to discourage dangerous behavior. We've talked about this before. I heard another member admit that public safety matters. That is what she said. Well, that's exactly what this bill addresses, issues of public safety. If it matters that much to you, you would vote yes for this bill. She said she's not advocating for blocked emergency vehicles. A vote no on this bill is advocating for blocked emergency vehicles. Another member said this is not a public safety issue. Well, if your grandmother were in an ambulance having a heart attack and on the way to the hospital, I think she might disagree with you. If your friend or neighbor was in a health emergency and needed safe transport to the hospital but could not get there or was forced to divert because of the self-described free speech issues, you might consider it a public safety issue. Another member described it as an attack on free speech. I've read the bill. I assume that everyone here has read the bill. I haven't seen one thing on this bill that obstructs anyone's right to free speech. Unless we forget, let me read line 11. A person who, without authority of law, purposely and recklessly obstructs any highway in such a way as to render it impassable without unreasonable inconvenience or hazard, and fails or refuses to remove the obstruction after receiving a reasonable request or the order of a police officer that he or she do so. Another member said this is criminalizing advocacy. I haven't seen anything in the bill that criminalizes advocacy. What the bill does is enhances the penalty for something that is already a crime in Georgia. And lest anyone thinks that a standard misdemeanor is a deterrent, it's a $100 fine in some cases. And I would argue very little is deterred by a $100 fine. I heard a criminal defense attorney say the most dangerous part of this bill is the civil penalties. And I thought about that for a moment. I know members of this body that have never met a civil penalty that they didn't like. So it makes me wonder, if someone commits a crime without authority of law, purposely obstructs a roadway and affects my ability to get to work, your ability to get to work, your ability to earn a living, why shouldn't that person be civilly liable? If the person has obstructed a road in such a way that you are unable to get needed medical care, why shouldn't that person be responsible for their actions? I regard the civil penalties as deterrents. That's what we want to do. I think a comment was made here earlier that folks, knowing what they stand to lose financially as a result of civil penalties, might not engage in free speech or protest activities. They can engage in free speech and protest activities as long as it's within the confines of the law. Not someone who purposely, without the authority of law, recklessly obstructs a highway. The civil penalty is a deterrent. Folks, I would suggest, as we contemplate the bill, that we really truly think about what it is we're trying to achieve here. There are thousands of ways to exercise your First Amendment right to civilly assemble in a way that does not hamper the safety of your neighbors, the public safety of your constituents. That is how we should engage lawfully protesting in a manner that is safe. Mr. Speaker, those are my comments, and I yield the well.
Lady has yielded the well. Representative Hagan, Chair Lady Hagan is recognized to speak to the bill.
Thank
You
you,
have
Mr.
about
Speaker.
6 minutes, ma'am.
Yes, sir. I will not take that long. This is a very short bill. I think I counted 24 lines, and only 10 of those lines are changes to our current code. So I just wanted to make sure I put that in perspective for you. Everybody, I don't know that anybody in this chamber or in this building would say that they do not believe that the right to protest is very important. It certainly is. But blocking traffic in the name of protest is not just an inconvenience for those who cannot pass. It's impeding first responders, school buses, hardworking people. The very hardworking people that many have come to this well and say that they are against the bill because this can hurt hardworking people. But when hardworking people cannot get to their shift to earn a living, to support their family, that's a problem for me. And it's a problem for my constituents. That's why I'm asking you to vote in favor of this bill. Protest does not need to include putting children or those in need in jeopardy. It does not need to include impeding people from going to their job. It certainly does not need to include destroying the property of hardworking people. This bill is not about stifling the right to lawful protest in any way. This bill is not about preventing voices from being heard in any way. I think it's worth mentioning that some have come to the well and said that the part of the bill they don't approve of or they don't support is the piece on civil liability for damages. But I think that is the most important part of this bill. One member mentioned that they're concerned about people living paycheck to paycheck. Well, friends, most of our small business owners are living paycheck to paycheck. And they need our protection too. And that is the intent of this bill. So, colleagues, I ask you to support this bill, to vote yes on this bill. It is a bill about public safety and holding people accountable for destroying the property of others. Simply that. In no way is this bill about impeding anyone's right to speak or their right to lawfully protest. Again, I do ask you to vote yes on this bill. Thank you, Mr. Speaker.
Ladies yielded the well. That completes our discussion on Senate Bill 443. Is any objection to the previous question being ordered? Hearing none, the previous question is ordered. Well, now we had chair's time, and the chair waves. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Hearing none, the report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk will unlock the machine. Have all members voted? All members voted. If so, Mr. Clerk will lock the machine. On the passage of Senate Bill 443, the yeas are 96, the nays are 69. This bill having received the requisite constitutional majority is therefore passed. For what purpose does Representative Blackman rise?
Make a motion.
State your motion.
Mr. Speaker, I move that Senate Bill 566 be recommitted to the Rules Committee. Need to make a date change.
And Mr. Clerk will read the caption.
Senate Bill 566 by Senator Huffstetler, the 52nd, to be entitled an act to amend Chapter 5 of Title 4080 of the Official Code of Georgia annotated relating to ad valorem taxation of property.
Thank you, Mr. Clerk. On the gentleman's motion that Senate Bill 566 be withdrawn from the calendar and recommitted to the Rules Committee, is there objection? Hearing none, is so ordered. Madam Minority Leader. Members, we have several bills, local legislation bills. Then this is the last day, so we want to make sure all the members get their bills in. So I'm going to recognize the chairman of that committee for a motion.
Mr. Speaker, I'd like to make a motion.
State your motion.
I would like to temporarily suspend the rules for the first time so the bills can be read and assigned to committee.
Would you, can we amend that motion, just we'll adopt the rules in the box without having to read each one of those? I think, spoken to the leader, and we're in agreement with that.
I'd like to make a motion.
Okay, state your motion.
I'd like to make a motion that we temporarily suspend the rules so that we can adopt the bills that are in the box as a whole and assign to committee.
Efficiency in government. Is there any objection? You don't get that very often, do you? Thank you, members. Thank you, Mr. Chairman. Motion carries. And those bills will be assigned to intergovernmental coordination. Some more work for you, Mr. Chairman. Members, we're going to discuss some. Hold just one second, Mr. Clerk. You've got a whole nother box, those privilege resolutions. We're going to postpone, while we're on the rules calendar, postpone Senate Bill 23 will be postponed to the next legislative day. Mr. Clerk, will you read the caption of a group of privileged resolutions?
Honoring the life and memory of Bishop Adekina Adejube. Recognizing March 26, 2026 as We Are CASA Day at the state capitol. Recognizing and commending Jim Frick. Recognizing and commending the school psychologists serving the students and families of Henry County Schools. Recognizing and commending the Hands of Hope Clinic. Recognizing and commending the Georgia Caribbean American Heritage Coalition. Recognizing and commending Michael Prochaska and Amanda Prochaska for their years of service at the Oconee Enterprise. Recognizing and commending Farrell. Commending the House Media's Services Session Assistants for the 2026 regular session of the General Assembly of Georgia. Commending the House Interns for the 2026 regular session of the General Assembly of Georgia. Recognizing and commending the House Session Assistants for the 2026 regular session of the General Assembly of Georgia. Recognizing and commending the Rabun County High School's boys basketball team. Honoring the Natural Gas Association of Georgia's 10th anniversary. Recognizing and commending Alexander Burgosh. Recognizing and commending Andre Enescu. Recognizing and commending Aaron Johnson. Recognizing the important role of Georgia's forensic nurses. Recognizing and commending Tamika Harris. Recognizing and commending Rashida Frost. Recognizing and commending Maria Hugh. Commending and celebrating the observance of Diwali and its cultural, spiritual, and community significance. Commending and congratulating Halen Christopher Poole. Recognizing the importance of theater education. Recognizing April 2026 as Autism Acceptance Month and April 2nd, 2026 as World Autism Awareness Day. And for other purposes, that completes the reading of the privilege resolutions.
Is there any question, objection to adopting the privilege resolutions? Hearing none, the resolutions are adopted. We'll move on to afternoon orders. Representative Ali is recognized for an afternoon order. Please give the gentleman your attention.
Thank you, Mr. Speaker. Members, on the screen is 6-year-old Shabani, who was born in 2019. He gets along well with others, enjoys playing with other children, but he mostly enjoys watching Paw Patrol and Peppa Pig. And with that being said, it is always in tradition that this is a foster child who's looking to be adopted, and we can make it possible at itsmyturnnow.dhs.georgia.gov. Thank you, Mr. Speaker. I yield the well.
How old did you say he is?
6.
6 years old. Good-looking young man. Thank you. We'll move on to announcements. Chairman Corbett, recognized for an announcement.
Thank you, Mr. Speaker. The Motor Vehicles Committee will meet at 10 a.m. in the morning, room 606. The Rural Caucus will be meeting at 12 down at the Ag Building. We will have lunch. And another announcement, there's a email or text going out, and it's a scam. It says from the Department of Driver Services. It's fraud wanting you to pay a citation. Mr. Speaker.
You might need to hear this one, members.
Thank you, Mr. Speaker. Yeah, there is a text going around. Several members have gotten this, and it says it comes from the Georgia Department of Driver Services, saying that you have unpaid citations, traffic fines, they're going to suspend your license. That's a scam. Do not open it. I've talked with the Department of Driver Services, and they are aware of it. So thank y'all.
Thanks, Mr. Chairman, for letting us know that. Chairman Hatchett, recognized for an announcement.
Thank you, Mr. Speaker. The full Appropriations Committee will meet in the morning at 8 a.m. in room 341. Full Appropriations. We got a little bill to take up.
6 a.m. or 8 a.m.? What'd you say? 8 a.m. 8 a.m. Gotcha. 8 a.m. Full Appropriations. Chairman Hawkins, recognized for an announcement.
Committee on Health will meet upon adjournment in 403. The sooner you get there, the sooner you get to go home.
Chairman Scoggins, Chairman was recognized for an announcement.
Thank you, Mr. Speaker. Special rules will meet at 5:15 upon adjournment. 5:15.
Chairman Dickey, recognized for an announcement.
Thank you, Mr. Speaker. Agriculture and Consumer Affairs will be meeting at 11 o'clock, 6:06 tomorrow.
Chairman Irwin, recognized for an announcement.
Thank you, Mr. Speaker. House Full Education Committee will meet upon adjournment in room CLOB 506. Thank you.
Chairman Crow, recognized for an announcement.
Thank you, Mr. Speaker. The House Public Safety and Homeland Security Committee will be meeting tomorrow morning at 10 a.m. in room 506 of the CLOB. 506 CLOB, 10 a.m. tomorrow for Public Safety and Homeland Security. Thank you, Mr. Speaker.
Thank you for those announcements. We do have and that concludes our announcements. I don't see anyone with another one. So we do have a birthday today, and I think the gentleman's already out celebrating. Let's all wish Representative Chaz Cannon a happy birthday. I guess you'll have to text him. Thank you for all of you that had pages today. Thank you for getting your pages here and doing their good work today. I'm going to recognize the Majority Leader of this House for a motion. Mr. Majority Leader.
Thank you, Mr. Speaker. I move that this House stand adjourned until Wednesday, March 25th, 2026 at 10 o'clock a.m.
On the motion of Majority Leader Estration, this House stand adjourned until Wednesday, March 25th, 2026. All those in favor will say aye. It's getting better. All those opposed, no. Come on, y'all, you can't vote twice. The ayes clearly have it. This House stands adjourned.